I move amendments 1 to 11 as circulated in my name together.
The member for Warringah has the call.
Thank you, Mr Speaker. I move the amendments as circulated. These are important because after extensive consultation with businesses in Warringah, broader organisations such as COSBOA, the Business Council, and having briefings, of course, with the unions as well, but also liaising with small businesses and local chambers of commerce, there is an incredibly high level of concern at the overreach of this legislation. No one has disputed throughout the course of this debate around all the amendments that some of the intent is genuine. But in relation to much of these amendments, I feel that it's a sledgehammer being taken to a whole area rather than being more specific. In particular, in relation to the definition and the issue of casual employment. And I should say for the Minister, I'm sure he would be aware, but it came to quite a surprise for me, is just how many different definitions of small business we have in Commonwealth legislation. He's nodding his head, so I'm assuming we currently have 12 different definitions of small businesses across Commonwealth legislation. So it's very important when we start to think of different provisions that apply, provisions such as in this legislation that apply differently for small business to big business. Some businesses won't even know under which piece of legislation they are considered a small business, and others they are a larger business. And that becomes incredibly important when we have questions of compliance and serious consequences. The amendments that I move seem to reverse some of the changes proposed in relation to casual employment, in particular because, under this legislation, the conversion the proposal is that there will be a conversion after 12 months for a small business, but 6 months for a larger business. The amendment I move restores the conversion to 12 months instead of 6 months for some for all businesses, for that very question of so many different definitions of small businesses. Other amendment removes this new definition of casual. The other amendment removes the firm advancement commitment of continuing or ongoing work as a grounds of conversion, and introduces the right that conversion can be refused where the role will not be necessary and/or will be significantly changed within the following 12 months. And this is incredibly important because where, for example, retail stores may be intended to be shut or there might be a restructure planned, the loss of that flexibility for businesses will be incredibly important. And it's important that businesses may be able to argue against conversion of a casual employee to a permanent employee on the basis of that there is likely to be or significantly changes within the next 12 months. As I noted on my speech on this bill several weeks ago, the change of the definition of casual and the related provisions caused a lot of uncertainty for business in the government's original bill. It will introduce a degree of rigidity into the employment environment, which it is highly likely to have unintended consequences, and see businesses more reluctant to hire additional casuals where we are already facing significant headwinds in our economy, and they are likely to carry through to 2024. And I note the comments of the Minister in relation to different views on these issues, but I think it is important to note that whilst there has been consultation on this bill, there hasn't really been assessment as to likely impact and real workshopping of ironing out those unintended consequences. So I'm concerned that the government's original bill, without these amendments, contains a significant degree of doesn't contain a sufficient degree of flexibility for employers and employees, and accordingly some businesses will suffer. And it is this sledgehammer approach. In particular, casual work is key for many workers, including students, parents who want flexibility, some regularly, and provides for higher take-home pay with an average of 25% loading. Younger Australians getting their first job, learning to work, gaining key employability skills. I really want to emphasise that point. Casual work is an entry point for so many young Australians and is incredibly important. And particularly small businesses in hospitality, retail, navigating uncertainty and changing conditions Can I seek an extension? Thank you. Changing conditions, it's incredibly important that small businesses be able to continue having that flexibility of casuals. But with that flexibility is often a regular agreement as to what days and hours a person will work. If I take the example of a parent, they do want to know that they are going to work on a casual base Monday, Wednesday, Friday, because they are the days they have childcare organised, for example. And you start, but if there are changes to their provisions or childcare, they want to also be able to change those agreements of days of work. And so losing that flexibility is incredibly difficult and I think dangerous for small businesses, but also for the people looking to work in an environment that works for them. I would argue the current definition works. It's clear and reliable for both employees and employers. Complicating the definition as the government proposes will only cause confusion. In relation to the firm advance commitment aspect of continuing or ongoing work as grounds for conversion, it makes no real difference as you cannot provide an advance commitment, which means you cannot give a casual worker a roster. Again, it's more uncertainty, more confusion from the rules that are already there. And it's that complexity that so many businesses are really objecting to. And in difficult economic times, the government should be focusing on making things simpler to really assist when it comes to cost of living crisis and giving businesses that certainty. The key message I hear from businesses in Warringah and around the country is more red tape, more confusion, more complicated legislative change is just making it harder for them. So I would urge the government to consider these amendments, if not in this place, in the other place, to make things much simpler for small business and keep flexibility in the system.
The question is that the amendments be agreed to, and I call the Honourable Minister.
Thank you very much, Deputy Speaker. And I thank the member for Warringah, and as I've acknowledged with the other crossbench members, there's no doubt the member for Warringah has always been very closely engaged with the businesses in her electorate. I remember, and if there was ever evidence of that, it was the confidence when the member for Warringah first arrived here, and a whole lot of people not from my party said, "Oh, she'll only be here for one term." So the engagement is strong, and what that brings to the chamber is respected. I want to explain briefly on one and then a bit more detail on the other two as to why the government's voting against these amendments. The examples that were given with respect to the 6 to 12-month change are examples which the government believes would in fact already be covered by the fact that you would have to have a firm advance commitment and the requirement of fair and reasonable, both of which are contained in the definitions. The government doesn't believe, and I certainly don't believe, that the sorts of examples the member for Warringah gave would end up in fact being problems. I think those sorts of examples of flexibility and surge would be covered by the provisions that I just referred to. But in terms of the other very significant things that these amendments do, is they delete the definition of a casual and they delete the definition of employment. And while I respect, in terms of legislation, what we are doing on these definitions is new, in terms of Australian law, it's not. We had massive change in very recent years as to what was the accepted legal definition of a casual and what was the accepted legal definition of employment. And effectively, the court went to a position where it, on both, effectively said, whatever your contract says, we're no longer looking at objectively what's going on. Whatever your contract says, that's the end of the story. And what these amendments are attempting to do is effectively, as close as you can with legislation, because obviously you can never do it identically because the common law is not like that, as the member for Warringah knows better than most people in this room, that to reflect what was believed to be the definition of casual and the definition of employment prior to those court cases. And to simply, I think the best examples I can give is to refer to the facts of those court cases to explain the problem we are wanting to solve. So the Rosato case was a case about a casual who, under common law, normally would have been regarded to be a casual. Would have been regarded to be a permanent, but was found by the court to be a casual. What were the circumstances of that worker? They worked for a labour hire company called WorkPack. On commencement, they were given a 12-month full-time roster. 12-month full-time roster from the start, and were told they were a casual. Now, objectively, being given a 12-month full-time roster would have been seen as you have the security of permanent employment. And up until the Rosado case, most people would have presumed that was where the law rested. The court found otherwise, and this is attempting to return to an objective definition of a casual, which we made a specific election commitment on. Similarly, the cases of JAMSEC and personnel contracting changed the definition of employment in a way of where it had previously been a much more practical common law definition, and it became effectively whatever the contract says. That now determines whether you're an employee. And the best example I can give of this is the example that was in personnel contracting, where a backpacker turns up to a construction site and all they have in terms of their equipment or skills that they bring, and I quote, were a hard hat, boots and a strong constitution. And they were told to get an ABN because they were actually being told they were a small business, they weren't an employee. And on every objective definition, that backpacker was not running a small business. And so the definition of employment, which is there in the Act, while it's new, it wasn't previously in the Act. Previously it didn't need to be because the common law had presumed a practical objective definition of employment. The High Court has now decided that's not the case, and the Parliament basically has to make a decision on both casuals and employment as to whether we want to allow the High Court's ruling there to be how we want to govern employment law. And the view of the government is the person turning up where their only equipment is hard hat and boots and their only skill that they're bringing to it is strong constitution. We don't believe that backpacker was a small business. We believe it was the fudging of an employment relationship. And similarly for the casual who was given a 12-month... Sorry?
Is it extension of time?
Call again. Similarly for the labour hire worker who was given a 12-month full-time roster and wanted to be seen to be a permanent worker, we don't believe that they should be found to be a casual simply because that was the contract that the employer signed on day one. So that's the problem that we're trying to solve, and they're the reasons why we don't support the amendment that has been moved.
The question is that the amendments be agreed to, and I call the Honourable Member for Warringah.
Clarifications response, but I would argue you've actually just proved the very point that I was making, that you're taking a sledgehammer to particular problems by making it so far-reaching in relation to many, many more businesses. You're taking a couple of instances that had broad reach, but because of where your definition of small business lies and because of the broad application of the change you're making, the only real defence you're providing is that there will be an interpretation of around the reasonableness and the interpretation around the advance roster that will be sufficient to prevent this legislation impacting a much greater number of businesses that you appear to intend to be impacted. And that's where the argument is, this is not fine-tuned enough so that the very particular cases of bad actors that you are attempting to deal with, but ultimately the court interpreted the legalities and stood by the terms of the contract by which that employment was governed. And you know, I think there is merit in that interpretation, even though it was not the one that maybe the side of government would prefer the interpretation of the court to have been. At the end of the day, it is the problem I have, and I think many of my colleagues have with this legislation, is that in attempting to deal with a more particular issue, it is going to have much broader impact.